7th and welcome everyone to the 7th and final meeting of the Senate Bill 460 work group. I'm Andrew Tress, Director of Government Relations at the Maryland Insurance Administration. Also with us today, we have Commissioner Kathleen Bahrain, Senator Malcolm Augustine, Delegate Bonnie Cullison, Ann Seacott, Betty Diner, David Cooney, Ellen Weber, Van Dorsey, Joy Hatchett, Kimberly Camarada, Mary Quay, Morgan Mills, Neil Karhanis, and Patricia O'Connor. So with that, I believe we're making some adjustments to the agenda. Initially, I was going to start off by giving the summary of the comments, but with time constraints, Commissioner Bahrain, I believe you would like to instead review the legislation first.
Well, I think I'm going to ask the senator and the delegate. One of the things that we can do to respect their time frame and their need to move a little earlier today would be to, one, go through the legislation first so that they can hear from the speakers with respect to what we sent out earlier this week. And the other thing I can do is just bring up now what I was going to say at the very end, which is that our intent at the end of this is to prepare a report that just lays out a summary of what happened at the meetings and provides a piece of draft legislation that hopefully has primarily the input from Senator Augustine and Delegate Cullison, the members of the General Assembly. It is not my intent to suggest in that report that there has been consensus, because clearly there are areas where there is not consensus. But we will have preserved both through these recordings and through the comments, areas where there are differences. And therefore that does not preclude anybody from, submitting their own draft, or if there is legislation that is submitted by a sponsor from seeking to change that. So it's not my intent to try to suggest that this particular draft is going to have been a consensus draft by the working group, because I think that that is clearly not the case, and we will be very transparent about that fact. So with that, if that works for you, Senator Augustine, and you, Delegate Cullison, I'm going to suggest that perhaps what I do at a high level is walk through the bill. And then I think what we could do is invite each person to give their comments so that everybody has a chance to speak. And then let you hear from anybody who is a member of the public who's on the line that would like to speak. And then, we can continue those conversations after you leave if there's more conversation to be had. Is that acceptable to you guys?
That sounds great to me.
Yes, thank you. Thank you.
Thank you.
Well, thank the two of you. So we did send out a draft of what could be a bill to be submitted this session. And it was posted and delivered to the members of the working group. So I'm just going to walk through it section by section. If there are specific questions as opposed to comments, maybe we can take questions as we go section by section. But in terms of, I like this, I don't like this, those kinds of comments that are more philosophical or go to an overarching kind of sense of this isn't what we want or this is what we want, maybe we could do that at the end and kind of just use the walkthrough time to see if there are something specific to the language or, questions about the language, and just kind of break it up that way. So the first change would be to the commercial law article to clarify, as did the original Senate Bill 460, that the HEAU is the state's Office of Health Insurance Consumer Assistance. So we wanted to maintain that clarification that that was the case. The second and the larger set of changes are to the insurance article and the addition of a new Title 34, which would establish within the administration a consumer health access program for behavioral health care and coverage. The point being there that it's both connecting people to care and addressing their coverage needs and issues that they might be having with either getting coverage or being able to utilize the coverage that they have acquired. There's a definitional section. We, instead of using the words mental health and substance use disorder, we felt that behavioral health care was actually a broader term. And so, Ellen, I can see you already shaking your head that you disagree. Those are the kinds of technical things that if you really think that we haven't made it broader, then, we'll be very happy to have your comments, because our intent was to have it be as broad as possible, and understanding that would operate under the rubric CHAP. But what CHAP would be for would be really every form of behavioral health care, mental health care, substance use disorders. So that was our intent. We kept the idea of the advisory council. We defined what a behavioral health navigator entity would be, those being sort of the notions of the spokes that would actually be primarily responsible for the delivery of the consumer assistance services. We kept the concept of the connector entity regions. We identified a group of consulting agencies that would come together to be able to provide support services and guidance, and would also receive data and analysis from the program. The consumer assistance services do not track identically what was in Senate Bill 460. They preserve many of the functions. What it does not include would be actually representing people in court or in a judicial proceeding. There is a data component that's further down. Keeps the fund. We kept the definition of health coverage, Mental Parity Act program. The idea of program-specific costs, and I have to see if that's a cleanup that's needed, but we're just trying to distinguish between the monies that the MIA will frankly provide in order to support and incubate the operations of the entity. So, space, HR, procurement, those kinds of operational services that are not unique to the particular services that are provided, dividing that notion and making sure they have a fiscal, somebody has a parking spot, that sort of stuff, versus things like hiring the navigators, right? Or actually hiring an executive director, because those would be program fund expenses. We kept the definition of provider. Then looking at the program itself, the next section establishes the program and establishes it as an independent division of the Maryland Insurance Administration. The next section identifies the purposes of the program to assist consumers to access behavioral health care. And I'm sorry, Andrew, I should have asked you to put this on the screen. People may be looking at things on their desk, but
No
Can I ask a question about that first section, Commissioner?
yes, ma'am.
Was it intentional for the consulting agencies to just have that all be government agencies and not any other, either provider or consumer oriented organization?
It is, because the council is where other organizations and consumer focused groups would participate. There was an effort to be clear about government coordinating in addition to service providers coordinating. So we saw the council as the place where there is coordination and guidance. For example, you'll see that the executive director is chosen with input from the consulting agencies and the council. So that's how we divided that up. And there is some information that is more readily and appropriately shared, and where de-identification and aggregation would not be necessary because you're sending it to another state agency, versus a circumstance where it would be through the council or through a group that would be external. Ellen?
Thanks, Commissioner. One question, and this is something we raised in our comments. Can you explain just a little bit more what it means to be an independent division of the MIA? and whether there is anything that exists right now that one could look to see what, how that operates.
So I would say that there are programs that have been set up within the administration that have utilized the way the fraud division used to be set up was that way, right? Where you had really a separate associate commissioner who had some independence from the MIA itself and from the commissioner. I kind of, I guess, borrowed this from a variety of sources that to anchor it here. The reason that I set it up as an independent agency within what I mean by independent agency within the MIA is that the executive director does not serve at the pleasure of the commissioner. So the notion, that's what makes the MIA an independent agency, is that the commissioner doesn't serve at the pleasure of the governor, that there's an appointment, and then once that appointment meets the statutory criteria, you can only be removed for cause. So the idea here was to have the MIA provide the supporting services, have the commissioner select the executive director in consultation with the agencies and the council, and then that person operates their program independently. So they're not under the control of the commissioner in terms of their selections or what they do. And if you think there's language that's necessary to make that clearer, you know, we can, in this bill moves forward, you know, that can be clarified. But that was the intent. And that's why when we get to the part about the executive director, it says what they can be removed for. Okay, so 34-202 looks at what the purposes of the program are. To assist consumers, to identify and coordinate efforts by agencies and other persons, which would include everybody, to assist consumers to access behavioral health care and coverage, provide for the performance of the services, and, you know, broadly through the activities of the program as a whole, through coordinating agencies, the navigation agencies, which are the most important part, and then other persons who might be engaged by or on behalf of the program. So that's recognizing that there are going to be statisticians, there may be data scientists, there may be other consultants who are, you know, brought into the picture, and then to collect, analyze, and report on data. 34-203 looks at the things that the group, and I borrowed heavily from the we borrowed heavily from the outlines of MHBE in terms of the sort of the outline of how to address the parts of this legislation, the idea of having, you know, what is its purpose, what is it required to do. So it incorporates the need to have a toll-free number, very much tracks the language of Senate Bill 460. We added in the idea of providing a website. Ultimately, nothing substitutes for personal communication through, you know, the toll-free number, but the idea of having a place where people can go and get information, but also being able to, you know, request assistance from on a website if that's their preference, is something we wanted to include. Yes, Ellen?
Thank you. Yeah, obviously your proposal gave some indications that the previous proposal, the narrative proposal, gave indications that you would be relying on 211, the health benefit exchange for these hotline services. Does that continue to be the thinking that underlies this draft? It was very clear in terms of the language that was actually used in the draft was, I don't have it right in front of me, but it wasn't that that the executive director would manage this, would be offering this. It was that this will be provided. And so that lack of clarity about that detail is a question that I had.
So I think that the goal of legislation is not to be regulation and to lay out the operational, you know, elements. So in the program that I was talking about, the idea of what could happen, I think that actually is the decision of the executive director working with the council and the consulting agencies to look at how do we provide a toll-free telephone hotline? What is the best, most efficient, effective way to do that? Because I think if we want to set this program up, legislation, if you look at the New York bill, there are literally 3 paragraphs in the legislation. That's what the legislation looks like, because the actual development of the program has happened through the auspices of the work of the executive director. So the goal of this legislation has been to articulate what they have to do, but not necessarily dictate the mechanism by which they do it. So that hopefully that answers the question. Is that they could certainly use 211. They could try to latch on to MHBE's call center. They could possibly stand something up themselves, although that, they may find that that's not practical. But it's opens, they have to provide it, doesn't say who they have to provide it through. Because you would want the executive director in connection with their team and the council to be deciding that, I think. Okay, the next
Thank you.
section, yep, sorry. The next section, which is 34204, gets to the executive director. So the idea is that the commissioner will appoint an executive director in consultation with the consulting agencies. That's an error. I thought we should include the council in that as well. They would serve for some amount of time, a term. They would report directly to the commissioner. That is just sort of state language in terms of like who signs their timesheets. But they can't be removed except for malfeasance or incompetence or their failure to carry out their duties. Those are the same bases on which the commissioner can be removed from office. So that's where they came from. There is no magic to this approach. In New York, this person is an independent contractor. That's another way to do it. I did it this way. It could be different. The goal with respect to the executive director is that they're the chief administrative officer of the program. They run the program. They perform all the duties necessary to carry out the program and the provisions of the title. They can employ and retain their own staff. They can hire their own independent contractors, attorneys, consultants, and other professionals or consultants. So that is the goal of that is to have them run the program independently and to make their decisions about who they're going to hire and who they're going to retain. And the job of the MIA is to provide the support staff to like do those procurements or provide, assistance in a more ministerial, if you will, way. So they would use our procurement officer, but they would be deciding the procurement. Okay, subtitle 3 addresses the fund. So there's a fund. The purpose of the fund is to provide for the program specific costs. The administration, our fiscal director would administer the fund. That's typical of all the special funds that run through the administration, whether they are for our work. For example, the reinsurance fund runs through the MIA, and our fiscal director oversees that fund and then remits the monies to MHBE. This is what the content of the fund would be. And then it would be a continuing fund, so it would not revert to the general fund. And there are blanks in here for what the budget allocation would be. Then 34401 addresses the behavioral health navigator entities that, in consultation with the consulting agencies and the advisory council, the executive director will engage the behavioral health navigator entities to perform those services. And it just says the block competitive bidding process. So I wish we didn't get the cross-reference in, but the idea would be to have a procurement process so that it's open and transparent. And there's a document attached to the RFP that sort of lays out clearly what the services are and the terms and conditions are. Mr. Carcanis?
Hello, good morning. I just want to say, first of all, just big picture, just how much we appreciate the work you all have put in on this. I know it's been quite a journey with all, about a dozen hours of meetings and all the staff time that you've put into it. So just first and foremost, thank you. On behalf of the carriers, I haven't gotten all the feedback quite yet, with the holidays and everything. So just wanted to reserve the right to circle back as necessary. On 34402 specifically, I just wanted to offer the recommendation that Behavioral Health Navigator should have like some type of baseline training on Maryland carrier networks, some baseline knowledge on policies and services and perhaps innovations that are offered outside of traditional contracts, and that they should obviously have the direct contacts with those carrier entities.
Okay, thank you for that. Let me also make clear that we know that, we've been moving quickly. And so our expectation is that at the end of this, we'll invite people to make comments and submit those comments. We'll collect those comments. We'll make sure that the members of the General Assembly who are on this group have those comments, and we'll work with them to do a final sort of whatever technical changes, and then deliver that for them to be able to decide how they want to address it. So, Ms. Weber? Need your hand up.
Yep, I did. Thank you. I appreciate that. The language that you have in the draft that's bracketed, what's the meaning of that? Because again, the first one, A sub 1 is be organized as a nonprofit entity. I didn't know whether that was that was a question as to whether that should be the standard or what that actually meant. And then the other point was item number 7. Again, again, with all due respect, some of the main comments and critique of what SB 460 was a failure to identify all the various privacy laws, financial privacy standards that one needs to adhere to.
So let me cut you off for just 1 second so I can do them one at a time so I can keep it, so I came back sick from the NEIC, so I'm not running 100% here. So but bear with me. So with respect to the brackets in 1, these brackets are, there is something to be inserted there. So that bracket in 1 was my request that our AG identify the right language to make sure, is that the right language? Is that the correct legal term as a nonprofit entity? So I apologize that didn't get finished before we circulated it because we wanted to get it out. But the idea is that it is some form of an eleemosynary charitable 501c3 or 501c1, but I wanted to make sure that we use the right language.
Thank you.
You're welcome. And with respect to 7, new Maryland law, again, my apologies. What I was intending to cross-reference there is there's a set of standards about an information security program that allows to make sure that systems are secure. So my intent was to reference the law that went into effect on cybersecurity with respect to insurance companies, but I'm also open to another approach to look at. What I was trying to do was anchor it to a single standard of making sure that the navigator entity has the systems in place to protect data, and using the standards that were they're very high level principles-based standards that were in Senate Bill 260 that passed last year.
Thank you.
Yeah, so I wasn't just trying to say we're going to make up new laws or just general Maryland laws.
So please just, and this I don't think this goes to the comment section, although I can put it in the comment section. What I'm saying is, if there is an expectation of certain laws that have to be adhered to, that should be identified. That was one of the key issues that was raised, never really vetted throughout this committee, this work group. And that is one of the issues that obviously we very much paid attention to and want to address. But without any additional guidance on what you think is failing and missing, it's hard to do that.
Well, I think on privacy in particular, the issues didn't have to do just with, there were two separate issues. One had to do with what kind of security and data privacy program was there in place. And then secondly, what is the propriety of sharing information, period, regardless of how rigorous the security and data privacy, program might be, is there information that should not be shared outside of a state agency? So I think there were two different issues with regard to privacy. And I think the way that this addresses this is that it houses the information within a state agency. So that takes care of one element of it. And then it tells that agency what to collect and what to analyze and what elements to share where. And we'll get to that in section 5. And with regard to, for that information, that a navigator, which is contracted to a state agency, right? And the performance of these services is acting as a vendor for the provision of these services, that brings a layer of protection to that information, and protects that information against, for example, subpoenas and different types of, individual requests. So the goal here then is to make sure that that organization that has been engaged by the program to fulfill the role of the program has systems in place that they're able to protect the data that they're acquiring on the ground working with folks. So that's how those two elements are addressed in this. Okay, so then when we get to 5, this is the collection, analysis, and reporting of program data. Again, these are not regulations. They're not an operational, document, but they lay out the framework and the structure. So the idea is that part of the role of the program is to collect and analyze data. And these are elements that must be identified. So you're going to collect data specifically to analyze in order to identify these elements. And the data will be collected and that to share the data that's been collected and analyzed with the coordinating agencies to help them improve the work that they're doing. And then to submit an annual report. And these are the elements of what the report should include or must include. Mr. Karkanis?
Thank you. Yeah, it's great to hear on the outset of 34501, you mentioning that these aren't regs. So I imagine you're implying that through the regulatory process, we'll spell out more details on perhaps protecting some proprietary information, insight on like more specifics on what data might be collected, standardized, aggregated, how it's analyzed to like sort of create objectivity in a report, for example. Is that what you mean through the regulatory process, or do you think there's more to expand on here?
Well, I think the executive director, in consultation with the assistant attorneys general, will work through the idea of what the report needs to look like. So, in every report that we do, for example, we work with our AGs to make sure that we're carrying out the requirements of the statute and, meeting all of the other guidelines. The executive director ultimately may decide that they understand what they need to do here, and, work from the language of the statute. Or they may decide that they need to, promulgate regulations. But this is ultimately their work product. And you don't always need a regulation in order to get down to the details of what the actual specific outline and content are of the report are going to be. But hopefully that.
Yeah, I think we just want to make sure that, and again, I haven't received feedback from everyone, but I anticipate that folks will want to have some sort of uniform approach to it, just something to just planting a seed on that issue.
Yeah, I mean, I think ultimately the goal here is for the executive director to be able to tell the General Assembly what they're finding and what they think the gaps and the needs are, and reporting on the details of the program and how it's worked. So in that context, I think it says de-identified and aggregate in terms of a public-facing document. So Ms. Weber?
Thanks, Commissioner. You mentioned one thing that I'm sorry that I neglected to ask you when we were talking about the independence of the ED. You identified just now that the executive director would speak with obviously the agency's attorney general. My question is, in the nature of an independent entity, will there be a different AG for this particular program? Will it be the AG of the MIA
So
in your vision?
So, to the extent, so I would say initially it would likely utilize someone in the MIA shop. So for example, when the Maryland Health Insurance Plan was created a number of years ago as a brand new entity back in 2002 or 2003, when I was principal counsel, it did not have its own AG to begin with. Instead, we identified a single person who would serve as the Assistant Attorney General for the Maryland Health Insurance Plan. And they did all the setup work and the development of the bylaws and worked with the board of the MHIP. And they did that for, Dan, you can correct my recollection, but I think that was for at least 2 or 3 years. And then ultimately, from a budgetary standpoint, they had their own Assistant Attorney General who was dedicated only to them and it didn't come through an MIA pin. So I think that the ultimate, initially, the idea here is that this entity will incubate within the MIA and it will use the resources that generally that the MIA has, and that would include having an Assistant Attorney General from our group, at least initially. Over time, we see these programs as they grow. It may make sense for there to be a person who is assigned to them solely. They also have the ability to hire consultants, including attorneys. So we included that authority within the purview of the executive director.
Thanks.
Sure. And then the subtitle 6 addresses the Consumer Health Access Advisory Council, which just lays out representation. And it's consistent with the notes that we had provided earlier. And then the last part of it is the picking up the state finance and procurement article, which makes clear that the plan, doesn't roll, any monies that are left over in the fund don't roll up to the state, that they remain segregated and separate. Mr. Karkanis?
Thanks. I'm sure it comes as no surprise on 34601 just to recommend carrier representation. Maybe I missed it, but we'd like that.
Okay,
Thank you.
that makes sense. But ultimately, Ellen, was that in the original bill? The idea of a carrier representation?
It was.
Well, that's our mistake then. So my apologies.
No worries. It's all good.
So that is, sort of the outline of the bill. If you want to take it down, Andrew. I think perhaps with the time that's remaining, before we lose Senator Augustine, what might make sense is if we hear from the members, maybe briefly, of their, kind of overarching thoughts, concerns, issues, so that they have the benefit of that. Again, it's the intent. The intent is not to cut anybody off, but to, have folks provide their written comments, which we will collect and collate, and we'll make some adjustments here. And then as we prepare our final report, which, as I said before, we will make very clear that this document, and I will change the name from 460 work group draft, because I don't really think it's fair to call that a representation of, as though it were the working group that blessed it, because I don't think the working group is blessing that. But we'll have a draft, and we will circulate that, and we will make it very clear where the areas of disagreement remain. So with that, Andrew, why don't I just ask you to, if you can just call the names of the members of the working group and see if they want to be heard.
Sure. So I guess we'll start. Well,
Can I jump in there, Andrew?
yeah, I was just about to say, I guess, set them out.
Yeah.
Seeing if you want to start.
Sure, yeah. What I'll start with, and I look forward to hearing what everybody's comments are. I will start though by just thanking everybody for putting in the amount of time and effort to look at the issue of people who are having trouble accessing their behavioral health benefits. And that for me, this remains the central effort of this is trying to help as many people as possible to be able to get the care that they need. And so I'm grateful for the effort that's been put into this. I am disappointed that we never did really talk about that which were the objections to the original bill. That just never happened. I am disappointed that just didn't happen. I do hope that it's made very clear in the report that you put out, that I just feel like that we just never did that, or that those objections no longer exist, which I've said before, because we just really didn't talk about them. We instead have talked much higher level about than the actual sort of legislation itself, philosophical versus the actual legislation, which is what we were sent to do. So I just would want to make sure that I share that with this group. But I am, though, as I said, very grateful for all of the effort, all the time that's being put into addressing this area of concern, which is still just such a big area of need that we have to do. We must, I feel everybody is committed to try to do something about. And so I still stand really, steadfast on doing that. So thank you for the time. And like I said, I look forward to the report and sharing that information forward as we continue to work in this space. Thank you.
Thank you, Delegate Carlson. Do you have anything you'd like to add?
Sorry, I had to step away for just a moment. I'm not sure where you are, except I guess what I would add is my thanks for the work that everyone on the group has done. I think, my read of this draft language is that there was every effort to make sure that the goals of SB 460 from last year were met. And so it just was maybe in a different way than was originally conceived. And, I'm a person who believes that there are multiple options to resolving issues. So I appreciate the fact that the advocates helped us to clearly define the needs. And I think they're addressed in here. And I think that there's some safeguards around, making sure, especially with the council, that we are living up to the expectations of the program, that we are actually meeting those needs. So I don't, it's not perfect yet. I think we do have some places where we need to make some clarifications, but and and look forward to working with folks on making those changes and tweaks as we need to. So not sure if that's what you were asking for, but those are my remarks on the overall bill, and I appreciate your time and thoughtfulness on this.
Thank you. I'm just going to kind of go down the list here. Yes, Neil, did you have any other additional comments or thoughts on the legislation?
No specifics, but just to echo what's already been said, just want to say how much we appreciate everyone's effort, work group members, MIA staff, and leadership. It's been a process. We have a long ways to go with session, of course, and we're here and happy to help. Just want to say, generally, we do agree, that having the MIA house this type of program makes a lot of sense, creates a lot of protections, especially with data. But like I said, happy to be helpful moving forward.
Thank you. Ms. Seacott?
Thanks. So I think many of you know that I represent a number of organizations that are members of the Maryland Parity Coalition. And I am in the process of getting some feedback from them about this proposal. What I do know, I think generally where they are is that their preference would still be to have an actual independent entity providing the service or coordinating the service. And if it wasn't that perhaps there'd be more consideration given to having it in the Attorney General's office as opposed to the MIA, just in terms of having a greater consumer focus. And I think that that's kind of the area where people have a lot of questions is the Senate Bill 460 had a very strong consumer-oriented perspective and involvement, and this has very little, just in an advisory council. So I think that that's some of the preliminary feedback that I'm getting. But that's not to negate the work that everybody put into this. I think it obviously is a lot of hours that everybody put in. And that's very much appreciated. But we'll be circling back, and as has been said, we've got a long process still ahead of us.
Thank you. Ms. Casemeyer?
Not a lot additional comments to add to what's already been said. I think thanks again to all the work that's been done, especially from the folks internal to the MIA and all of us, all of you all in the work group. I feel like I may have done the least of anyone on this work group, but anyway, but I would say echo a little bit of what Ann said, only in that I, as you all know, represent a number of organizations, provider organizations and others that are interested in this. I think, and I'm still getting comments and we'll be working through the session. I think the comments I'm receiving back are less about where it's housed or how, as much as ensuring that the consumer voice is well reflected and that it is structured in a way that recognizes the limitations of other avenues that have already existed for a long time and not worked to get people access to resolving their need for services and inability and challenges to find them. So I think it's not so much from my client's perspective where it's housed as much as what the input is and the attention to the consumer voice that gets built into the legislation.
Thank you. Mr. O'Connor? Not. How about Ms. Mills?
Yeah, I do want to thank everyone for the work that they've been putting in, but I do just want to echo the previous comments. Here at NAMI Maryland, we would agree that the preference would be to have this agency exist independently to really ensure that the voice of the consumer is heard. We recognize that we have quite a bit of work ahead of us, but we're ready to tackle these hurdles. And again, I want to thank everyone for the work that has been put in over these past several months.
Thank you. Ms. Camarada?
Hi, everyone. A few things, and I echo what everyone else said. And I hope you can hear me through my mask, but I'm dealing with a COVID outbreak in my home. I echo everyone else and thank everyone for their work on this. I just have just a few things. One, I mean, a couple are very specific, and I know they'll come out and we'll include them in our comments. But when listing the types of health plans to be included in this draft, we would definitely recommend specific inclusion of the state employee health plan. We've had some issues with appeals related to the state employee health plan that we outlined in our most recent report to the General Assembly. And to try to ameliorate some of those issues, we would certainly recommend including them specifically. And it may well be we want to include the federal employee health benefit plan as well, because we do help a lot of federal employees here in our state. We also, it's not completely clear to me from this legislation, as was true of actually the original Senate bill, as to how the HEAU would be used. And I point that out not from a turf lens, because we are not about turf. We are about providing the best assistance we can to consumers. And obviously we would like to continue to use the expertise that we've developed in helping consumers and continue to provide that assistance. Having said that, we're asking in part because to give us a better idea of what a fiscal note would look like and how our services would be used. And that may well be, Commissioner, that will sort of be the vision of the executive director in consultation with the coordinating council and coordinating agencies. But as I am just literally thinking logistics and input on this bill, those are the things that sort of come front of mind to me. And I also noticed there's sort of 3 years of the budget contained in the bill, but I don't see a sunset in this bill that was contained in the original bill. And I didn't know if that was just sort of a trying to get a bill drafted within the time constraints. But those are just sort of top of mind. Obviously, we'll go through the bill more carefully and give you our feedback. But we continue. We look forward to, as I've said throughout these meetings, having more resources available to the consumers that we try to assist every day, and frankly, being able to provide assistance to even more folks as they become aware of this program that's going to offer these valuable services.
Yeah, just on the time frame standpoint, we adopted the 3 years that were in the Senate Bill 460, and I think we really need to hear more from the legislators whether they perceive this as a pilot, which is what the original bill was, or whether they see this as sort of a more permanent program, and we will need to get that feedback before we finish that part of it.
Yeah, I figured it was a placeholder, but.
Thank you. And Quentin Askew.
Sorry about that. It's a little technical difficulties. Nothing to add other than what's been said. Just echoing the support that everybody's put in, the work that everyone's done, and we are definitely here to support the continued efforts, but nothing additional on what's been said.
Thank you. And I believe that is everyone. Yeah.
Andrew, hi, I haven't given you my comments.
Oh, I'm sorry, Ellen. My apologies.
That's all right. That's all right. So obviously, again, totally appreciate all the work that the MIA has done. I appreciate, Commissioner, that the final product that will come out of this will clearly indicate that this isn't a consensus bill, and that there is quite a bit of difference in the views. I want to echo the comments that Anne has made, comments that Pam Case-Myers made, and Kim Camerata, as well as some of the issues that really need to be concerned. Very quickly, with all due respect, for the reasons that we've outlined very clearly in our comments, we don't believe that the Maryland Insurance Administration is the place where this should be housed. As Kim has just clearly articulated, the range of health insurance that Maryland residents need assistance on is far, far beyond what the Maryland Insurance Administration has expertise in and regulates. In this context, the privately state-regulated insurance is a very small portion of it. So in fact, this appears more to be sort of the tail wagging the dog in providing the assistance. The Maryland Insurance Administration is not a place that many consumers think of coming to. Therefore, we really do believe an independent entity would be a far better approach to this. Just very specifically on some of the other points, with regard to the consumer assistance activities, several very important ones were not included. It does not focus on engaging the community in education and understanding and identifying the problems that really do exist. That was a key role of the navigators. Obviously, you have a navigator role in the bill, but there was not this articulation in the activities itself. We do believe client representation is critically important, even if you didn't include judicial matters or litigation. Individual client representation is a key component of all consumer assistance programs that adhere to best practices. That, in our view, is absolutely essential. And then the sentinel function that an independent entity offers is critically important. This does not speak to the privacy protections. It doesn't speak to the protections that would exist for information, but there is a unique sentinel role that an independent entity can perform. And we believe that, again, is a best practice. It's what was included in the ACA legislation for the creation of consumer assistance programs. We also don't believe that the role should include this coordination across agencies. We understand that there needs to be coordination by all agencies that deliver behavioral health services, but that should be going on. That should be the role of government itself. That should not be the distinct role of a consumer assistance program that really has to be targeted very, very closely on what the needs of consumers are and how do they individually gain access to insurance-based services. And so we really don't want the time and the energy of the executive director of the consulting agencies to be taken up by that function. It should be going on already, and it can go on independently without this legislation. And I believe the other issues have been discussed. I think the funding, though, the absence of a fiscal note on this is critically important to any decision-making process that can be done. We have no sense of what resources one envisions for this type of entity. And that, as we all know, makes all the difference in the world. So thank you for considering our comments. Obviously, we have much more detailed comments in the letter that was, again, signed on to by 17 different members of the Maryland Parity Coalition. Thank you very much.
Ellen. And Commissioner, seeing we jumped around the agenda a little bit, did you want to sort of go back to?
I don't think so. I think we have them posted. I think at this point, we really just want to see if there are any of the attendees that have something additional that they want to add to the discussion. I mean, I think we've heard very clearly from, folks sort of what they think and where the areas are, but very happy to take additional comments from our attendees if they want to be heard.
For those attending, if you please submit any additional comments into the chat.
Well, they should just indicate that they want to be heard, and we'll do what we usually do. I don't see anybody. I see Courtney has her hand up, so Craig, if you want to invite her over.
Yes.
Thank you.
Hi.
Hi, Ms.
Um,
Bergen.
so I agree with many of the comments that were already made about the appropriateness of this being housed in the MIA. With all due respect, I just think it's not addressing what the initial CHAP bill was intended to address. And I worry about the specific expertise needed to effectively serve the population that we're seeking to serve with this proposed legislation. And I think it could be done more effectively if it were done by an entity with some expertise, specifically with the population, because it seems like that's what's currently missing. And then the other thing I just wanted to note is that the term behavioral health really isn't a more inclusive term and can be really offensive to some. And so I think that I would strongly suggest that that be reconsidered and be revised to reflect mental health and substance use services.
Okay, well, thank you for that. The only thing I would point out is that that's the purpose of hiring an executive director, right? Is someone who has expertise and has the ability to operate this program as it's envisioned. If we just thought that the MIA was going to step into this role, it wouldn't be structured that way. So that the goal is to bring someone in who has the operational and background to be able to run the program and to hire the people that they need to run the program. But from a fiscal perspective, I agree. I think we need to hear some guidance about whether this is intended to be a 3-year pilot or whether this is intended to be more permanent, because that's going to inform the numbers. So the original bill had $1 million each year set aside, which, to run a pilot. And, that those $1 million doesn't go very far. So I don't know what the kind of the original thought and intent was with what was going to be accomplished with that $1 million a year for 3 years. But I think that we need to at least start with an understanding of is this intended to be, a long-term permanent thing, or is it intended to be a pilot? And we can go from there. And I hear you in terms of the verbiage, and not verbiage, I don't mean that in a specific way, but using the right words to identify what we mean, and that's an easy fix. So we can certainly accommodate that. Anybody else in the attendees who like to be heard on the bill? And then Senator Augustine, you have to go. I know. Thank you very, very much. And we'll catch up. If there are no other immediate comments, what I would just ask folks to do.
Thank you, everyone.
Oh,
I'm sorry. I've got to go. Thank you. We'll be in touch. Thank you.
Okay. What I would just urge people to do is to, and we'll, give you an open period over the course of the holidays and maybe, into the first week of January, perhaps, to provide additional comments. This is not a one and done. Even whatever ultimately the report looks like, this is going to be an area that going to have continued conversation. And our goal here has not been to, frankly, try to put together this document that, either Delegate Cullison or Senator Augustine can drop. Our goal here is to be in consultation with them to try to put together what they asked us to put together, which is an entity within the MIA that we think is, makes sense and could be operational, relatively quickly. But I'm confident that whatever the final version looks like, it will continue to have, there'll be lots of conversation around it, and we'll do our best to try to incorporate what we can.
Commissioner, if I might just add, again, my thanks, but also to let folks know, to expand a little bit on what you were just saying. I know the senator and I will be working closely. We will be talking to you. I do not anticipate us calling this entire group back together, but I do anticipate that we will be meeting with the various advocates to discuss some of the things that you've talked about here. And with MIA, see if we can come up with language that addresses the concerns that that you've raised. So again, it's not done. I would like to do this, and I suspect the senator the same way, relatively soon in session, because it is such a significant and comprehensive program. This is not the kind of thing that gets created overnight. And we are talking major impact. So I want us to begin early in the session so that we have a working product long before crossover that we can hopefully get through over crossover. So that's my goal. And I shouldn't speak for the senator, but I suspect he shares my goals as well. So thank you again.
All right, well, I think with that, we'll probably conclude today's meeting unless anybody has any final thoughts that they'd like to be heard on, and we'll kind of get to work and wish everybody a very, very happy holiday. I like to say happy, merry everything that you celebrate. Just maybe taking a little bit of time with your loved ones over the next, week or so. All right, anything else? Well, if not, thank you to everybody who participated. I am sorry for those who are unsatisfied, with where we wound up. We'll try to take thoughts, but ultimately, this is not our bill. This would be the bill of the senator and the delegate, and that's where I think the conversations will go from here. All right, take care.